My parents called me a failure at their anniversary. They stood at the front of the room, my father with a wine glass in his hand, my mother beside him, and my brother and sister sitting a few rows back like witnesses. My mother said it plainly. She never gave us grandchildren. She never settled down. She hasn't held a steady job in years. The toast was meant to be celebratory. Instead, she reached across the microphone and wrapped the sentence around me like a hand that would not let go. It landed in the middle of the dining room with the kind of small, surgical cruelty that leaves a bruise you can't see. That was the moment, out in front of 40 people at LaSalle's banquet hall, when I realized the house I'd inherited from time and caregiving was not mine at all. The house where I'd lived since college and where I had returned to care for them after the stroke, where I had been sleeping in a twin bed in my old room because the guest room was the only place for visitors, was being turned into evidence I had failed. They told their friends I had been given every chance and chosen poorly. They said it loud enough for their friends to nod. I sat at a table with a paper plate in my hands and a fist pressed to my knee, and I felt the room tilt. They did it because it was one thing my parents could still control when everything else felt fragile. Money had always been the language in our family, the ledger my father kept, the way my mother measured success in account balances and property lines. When a marriage fails, when health fails, when children grow into people who make different choices, money offers an easy script. The ledger translates life into numbers and assigns a verdict. That evening, they applied that verdict to me, and a single sentence made a quiet public law. I should explain who they were to me and why I could not simply walk away. My name is Anna. I was 39 at the time. I had a college degree and a decade of odd jobs, substitute teaching, administrative work at a nonprofit, coordinating volunteers for the food pantry. After my divorce, I moved back into my parents' house on West Jefferson, a two-story from the 1940s with creaky stairs and a lilac bush my mother insisted on pruning herself. The house belonged to the three of us in practice, my parents and me. Legally, everything was messy. My father had joint accounts with my mother. They had a will drafted in 1999, naming each other primary beneficiary, and with instructions for the house to be divided equally among their children upon mutual death. There was no trust, no modern estate planning, just the old will and the day-to-day economy we all relied on. I was the person who drove my mother to appointments, sat with her while she filled out forms, coaxed clear sentences out of her when memory failed. I paid for the groceries, for the light bulbs, for small repairs because my father was stubborn about letting someone else touch the tools he still kept in the garage. I was dependent on my parents in the sense that I was living in their house rent-free, and in exchange, I provided labor and presence. I had no savings. My divorce settlement had been modest, and much of what I had was consumed by the unpaid bills that come with being the person who answers every small emergency at home. While I had established a modest community legal clinic on the ground floor, a table against the wall where neighbors could come for help filling out forms, and where I informally counseled people about housing and benefits. It was not a business, it was a lifeline for people who could not afford a lawyer. That was part of why my parents' public denunciation stung so much. Everything I did that mattered had been done right there in the rooms they'd given me. After the anniversary, the betrayals came in small, sharp increments. The first wave was administrative and cold. A week after the toast, I discovered my name had been removed from the household checkbook. My father, who had always insisted on writing checks by hand, simply stopped handing me the register. I went to the kitchen, opened the dresser where it always sat, and the register was gone. Later, I found out they had closed the joint account and opened new ones with only my brother and sister as signatories. When I asked quietly, in the evenings when my father was awake and sober enough to be reasoned with, he said it was because he was sorting things out, because their financial advisor recommended simplifying affairs. "We're getting our ducks in a row," he said, repeating a phrase I had heard him use on vacation bills and tax forms. My reaction was confusion and a growing anxiety. I called my sister. She sounded apologetic and faintly impatient. "It's complicated," she told me, as if complexity were an adequate explanation for exclusion. The consequence was immediate. Suddenly, I had no access to any of the accounts I had relied on to buy groceries or pay the discipline fines for the small nonprofit events I ran. The second wave was social. Neighbors who had once waved hello began giving me cautious looks, as if I had some illness that could be seen. My mother's friends called and asked awkward questions about why I had not brought a casserole to the anniversary. My brother avoided me at family dinners, and when he did speak to me, it felt as if we were actors on a stage, and the script called for a superficial politeness. I tried to keep working the clinic. People showed up at the kitchen table with eviction notices and disability forms and the same quiet panic that used to be in my own chest. I sat with them and translated legalese into plain speech, but business dried up when the people I had relied on for references stopped answering calls. A grant my clinic had applied for $12,000 somehow disappeared from an agenda list at the neighborhood foundation. I learned later that my parents had complained about my mixed priorities to a board member who volunteered at church. The consequence? The clinic's rent went unpaid. The landlord called. I had no funds to cover the utilities. The third wave was explicit. Procedural betrayal. My mother's signature on a power of attorney form was changed without my knowledge. One night, while I slept in my old room, a courier delivered a packet of papers to the house. My mother signed them in a kitchen chair, my brother and sister leaning nearby like inspectors. The new power of attorney gave full health and financial decision rights to my sister, and it named my brother as secondary. When I asked to see the paperwork the next morning, my mother looked at me with an expression that was both exhausted and apologetic. "Your sister will handle the bills," she said. "You understand, Anna, we can't ask you for everything." Why it hurt me was not because they handed control to someone else. It was that they had taken control away without asking me, like removing the wick from a candle and deciding it had been burning too long. My reaction was to become more present, to attempt to rebuild trust. I made lists of medications, I learned call schedules, but the consequence was that conversations I had once been part of shifted to other rooms where I was not invited. Decisions about care were made without my input. They began to arrange for repairs and renovations in the house through my sister's people. I was still present, but I was no longer a stakeholder. After that, things accelerated. My sister began to treat my presence as a nuisance. She suggested, in an offhanded way at the next holiday, that perhaps my life would be better if I moved into a smaller place, closer to the city. She used the word opportunity and smiled as if those were the kind of gifts one handed out at church. When I objected, she accused me of being dramatic, of creating storms in teacups. Her voice had a practiced firmness that had always been useful at corporate meetings. Now she used it like a shield. My father started to take her side. He told me he had been thinking long term and that sometimes the people you love must make hard choices. There was humiliation in the ordinary domesticity of it. The way my sister organized curtains and wrote sticky notes and told me which drawer in the kitchen I could use. I reacted by trying to document things. I printed copies of the old will from 1999 and checked library records to see if the lawyer's office still had files. I recorded dates of bank closures and phone calls. My consequence for being methodical was that my sister accused me of paranoia and my father of being unsteady. The entire household used language that made me sound exasperated rather than wronged. People in my social circle began to drift away because they did not know which facts were mine and which were forgivable missteps. I was shrinking into a smaller orbit inside the house, which was absurd because it had once been my refuge. The fifth escalation came when the sister, now armed with power of attorney, began to move assets. She arranged a meeting with a real estate agent and spoke softly about liquidity. My reaction was to plead, to ask what would happen if we sold the house and the mother wanted to stay. She smiled in the way people with titles smile when they explain hard realities. "We'll find a better place," she said. "You can take a unit near the clinic." The consequence was immediate. An appraisal appeared on the kitchen counter. There were whispers of renovation and resale in the neighborhood market. Her friends, all of whom had jobs at banks and in real estate, started coming by under the guise of checking for needed repairs. The house that was the repository of my childhood was being evaluated like a commodity, and my opinion was catalogued as sentimental. This was the point where my ability to act sensibly collided with my reliance on the family's tangible resources. I had no access to the joint accounts. I couldn't take out a loan on a house I no longer seemed to own in spirit. I could afford neither a lawyer with enough patience to litigate elder law nor a motel. My clinic folded for a week when I missed a landlord payment. Some of the people who relied on me found other resources, and others fell through the cracks. It hurt because what I had built, small, fragile, human, began to vanish in real time, and I couldn't purchase a remedy. One evening, a neighbor came by with news she had heard at book club. The sister had started divorce proceedings in a different state for her ex-husband, and he was listing assets. The neighbor thought the sister might be trying to clean up exposure by moving property around. The neighbor, who had known me since I was a child, said quietly she had seen signatures on some documents that looked wrong, flat and hurried, as if someone had traced them. That murmured observation was small and informal, but it was the beginning of a trail. The sixth escalation was legal and direct. My sister filed papers at the county clerk's office that, on their face, looked routine. An affidavit declaring the recent changes in the parents' health, and a petition to consolidate assets into a family LLC. She was efficient. She paid the filing fees. My reaction was to go to the clerk's office and ask for copies. I sat at a scratch table and read the packets, and my stomach dropped when I saw that the affidavit included language stating that my parents had been of sound mind when they issued the power of attorney, and that they wished for their children to act in concert for the efficient disposition of property. The consequence was that the court system, which moves slowly, had already recorded the sister's intentions. It created a procedural barrier that made any immediate reversal difficult without clear evidence of wrongdoing. My efforts to get a temporary restraining order were delayed by the need for evidence. I felt as if I had entered a bureaucracy that had been made to slow down people like me. The seventh escalation was overt humiliation. At my mother's next doctor's appointment, my sister signed in as the official family member and asked the nurse within earshot why I was still living there. The nurse, who had previously greeted me by name, looked at me with that small professional pity that hurts because it's more honest than a lie. A cousin at the appointment pulled me aside and asked if I could afford to move to a smaller place. My reaction was to explain, quietly and with facts, that I was the one who had been managing the medications, that I had been the person who bathed my mother when she could not reach the faucet. The cousin's face softened and then cooled. She told me she didn't want to get involved. The consequence was that when decisions were being made about in-home care, I was increasingly considered an optional presence, not a primary caregiver. The eighth escalation arrived in the form of silence. My father had always been a man of few words, but lectured with a ledger more than his mouth. Now he spent longer at the dining room table on his own. He missed dinner more often. When he did speak, he seemed tentative. Sometimes he would say things like, "We need to be practical," and I would ask what that meant, and the reply would be a hedge. He called me once late at night and said, "Anna, it's not personal." That line was his attempt at mercy. I told him it had been personal for weeks. There was a long pause. The consequence was loneliness, one of the deepest, dull aches of that period. It drained my energy for argumentation and made me less effective at advocacy. I was depleted. One morning in October, I found an eviction notice taped to the front door. My sister had filed for ejectment, claiming I was a holdover tenant. The grounds were preposterous because I had not been paying rent, but the house was in my childhood and no lease had been written. Still, the clerk's office took the filing seriously as an administrative action. I reacted with disbelief and anger. I went to the legal aid clinic across town that helped tenants because I knew how to ask questions even when my head felt foggy. The attorney there looked at the forms and said there was a path. Prove that the eviction was retaliatory or that the power of attorney had been misused. We had no signed proof yet of misuse. The consequence was a scheduled hearing and the requirement that I produce evidence. My sense of leverage diminished. I had lost access to money, to allies inside the family, to the house itself. I felt as if the world had shifted its furniture without asking me whether I wanted to move. The low point followed not long after. It arrived on a wet Thursday. My mother had a fall in the kitchen and could not stand. The ambulance took her to the hospital. My sister arrived later in a new sedan, her hair coiffed, her voice practiced. At the hospital, she produced a signed consent form that allowed her to make decisions. The nurses consulted her. In the waiting room, with fluorescent lights and the smell of antiseptic, I felt the old ledger's pages flip shut. No one asked me which pain management plan would be best. Then, at 5 that afternoon, a social worker called me into a small interview room and said, the sister was recommending that my mother be discharged to a memory care facility while the house was being sold. I protested. I said my mother did not need that level of care. The social worker said politely that the sister's power of attorney carried weight. I remember sitting on a vinyl chair so hard the seam dug into my thigh. I felt the world collapse into a single concrete fact. I no longer had legal standing to decide what happened to my mother. That night, I slept with the eviction notice under my pillow. I cried for the first time in years because the pain was not a single event. It was a stacking of small betrayals. I had lost leverage and was being forced to watch people make choices about my life and my mother's in the shadow of paperwork. It was quiet, heavy, and absolute. The turning point was neither spectacular nor cinematic. It was a mistake. An email sent in haste by a lawyer who had been handling other clients for my sister. He had been sloppy. In his haste, he uploaded a draft of a deed and the old will to a county cloud folder with permissions set to public for a few hours. I found it because I had become methodical with searches, because I had spent sleepless nights logging into databases and probing for anything that did not fit. Finding the files felt like finding a torn page from a ledger. There it was, a scanned letter from my father to his lawyer dated August 12th, 2001. In it, he wrote in his thin, looping script, "Anna has always been the one to run to the house when things fall apart. She can stay in my room if she needs. Please make sure she is provided for." It was informal and hardly legalistic, but it carried weight because the signature matched his handwriting on other documents I had. There were other files too, an unsigned codicil that had been drafted but never finalized, and a scanned email thread where the lawyer expressed concern about the ethics of moving money while my mother's capacity was uncertain. It was a small mistake that had been left in a public place. It was a document that nobody thought to bury tightly enough. My reaction was a fierce, quiet clarity. I printed everything, took photographs of the files, and emailed copies to the legal aid clinic and a journalist I knew from covering housing issues. I did not shout. I wrote concise notes and attached the evidence. I called the county clerk and asked about the timing of filings. I asked questions that demanded answers. What followed was the slow, consequential mechanics of exposure. The journalist who had been covering elder care and had a good ear for the specific cruelty of family financial abuse wrote a small piece about procedural irregularities. The article was careful and did not sensationalize. It described the power of attorney and the filings and the existence of a draft codicil that suggested conflicting intentions. The reporter relied on public records and quoted the lawyer's own careless email as evidence that the process had not been entirely transparent. Within days, the county prosecutor's office opened a cursory inquiry into whether the transfers had been made with full consent. Because the lawyer had been sloppy, and because the documents showed signs that the will had been in flux, the inquiry had teeth. The governor's office called 3 weeks later. They did not call to offer sympathy. They called because the state had recently been debating elder financial protections, and the press had made my case a small local example. A policy advisor from the governor's office requested a meeting. The invitation felt surreal. I was still living out of boxes because I had been forced to pack things I thought I might need if an eviction happened. I sat in a small conference room at the state capitol and listened while a young aide described their interest in hearing from people who had experienced elder financial conflict firsthand. She said, "We don't want talk. We want concrete examples. We want people who did real work, with limited resources. There was something clinical in the way they had come to me, as if I were both the victim and a specimen. My initial reaction to the invitation was suspicion. Why would anyone in a governor's office want to listen to me? Would they merely be window dressing with a single story? I thought of all the times my parents had used language to shape narratives, and I braced for that possibility. I also saw an opportunity. The exposure might force procedural changes that could prevent what had happened to me from happening to other families. I tested the aide with a few questions about timelines, about what the governor's office hoped to accomplish, and was surprised to find that she had read the reporter's piece and understood the legal tangle. The consequence was that I agreed to meet with a small task force the week after the initial call. The meeting itself was not dramatic. The room smelled faintly of coffee and the building's old HVAC. The governor did not attend. Instead, a senior policy advisor and 2 aides sat across from me and asked steady, precise questions. They wanted to know about the sequence of events, the paperwork, and what practical changes could help people in similar circumstances. I spoke in plain terms about access to joint account audits, about the need for mandatory waiting periods on transfers when there is a sudden change in power of attorney, about the importance of clear documentation for wills, and about the fact that many older people sign things they do not fully understand because they trust family. I did not make grand claims. I described concrete incidents. The courier delivering the packet, the neighbor's observation of a forged signature, the lawyer's email left in a public folder. I laid out the ways in which someone without money or institutional knowledge, like me, can be pushed out of decisions about their own life. In the weeks that followed, the task force conducted interviews. The prosecutor's office requested additional documents. My sister's attorney called me and asked if we could resolve this quietly. I declined. The public attention had created leverage because the documents were public and because the lawyer's mistake had opened a window. My leverage was not vengeance, it was evidence and the legal mechanisms that evidence could activate. The consequences were procedural and, at times, slow. The county prosecutor suggested mediation to determine whether the power of attorney had been used appropriately. The court issued a temporary injunction preventing the sale of the house until a final decision could be made. That injunction was not a triumph, it was a pause. It bought me time. The legal aid attorney helped me get emergency motion access to the house for the purposes of caregiving. I was allowed back into the rooms I had known since childhood, not as an occupant, but as a contracted caregiver. The house was messy with people who had been cleaning and preparing for sale. In the kitchen, I found sticky notes in my mother's handwriting that said simply, "Anna, call." My mother had been trying to bridge the gap. Her short notes were the only honest pieces left in the house. The governor's office asked me to testify in front of a legislative committee that was considering a bill to increase protections for elders facing sudden asset transfers. I prepared for the hearing with my legal aid attorney. We coordinated statements that were factual and restrained. I did not rail. I described sequence, evidence, and the emotional drain of being excluded from fundamental decisions. On the day I testified, the committee listened. There were no grand scenes. There was only the sound of a gavel and a clerk reading the minutes and my voice describing in plain terms what happened. The bill did not pass that session, but the governor's office used my testimony to draft an executive order requiring better oversight in county filings and additional training for attorneys who represent elderly clients. It was not a sweeping change, but it was practical. In the private consequences, the prosecutor's inquiry revealed oddities in the signatures on the transfer documents. A handwriting analyst called by the prosecutor noted irregularities in the power of attorney forms and suggested further investigation. The sisters' lawyer, facing the prospect of a prolonged legal battle, suggested an out-of-court settlement. The settlement included a small monetary restitution and recognition that certain transfers would be rescinded pending a full accounting. It also included a clause that allowed me to remain in my mother's life as a primary caregiver. Not everything returned to its previous shape. The relationships were frayed, perhaps permanently. My sister and I spoke infrequently and formally. My father, at times, seemed relieved that an external authority had made decisions for him. My mother was quieter and sometimes distant, as if some part of her had been taken away along with the control. The practical payoff for me was modest, but significant. The injunction preserved the house from immediate sale, and the settlement restored some access to the accounts so I could cover the clinic's unpaid rent and get a modest stipend for caregiving. The clinic reopened with a small grant from a foundation that had been watching the case. The publicity had helped them see the practical value of the work. I found a small apartment 2 streets over, one with a window that faced the lilac bush in my parents' yard. It was a compromise. I was no longer sleeping in my childhood bed, but I could be at the house in 30 minutes if needed. How the relationship with my family had altered into a new configuration. I was no longer an assumed presence, but someone who negotiated contact and boundaries. That loss of assumed belonging was not fully recoverable. There were ethical lessons embedded in the consequences. Systems that rely on paperwork can be manipulated by people who are determined and who have resources. But I avoid framing it as a moralizing instruction. I will not claim that everything was learned. I will say only that certain procedural changes were possible once the right windows of attention opened. The governor's office used the case to propose clearer rules for attorney conduct and mandatory waiting periods for transfers when there are concerns about capacity. Those rules, if implemented, would help others. It was a sober or administrative victory rather than a triumphant flourish. The final scenes are quieter. My mother and I sit together on the back stoop in the evenings. She will sometimes hold my hand for a moment and then let it go. The house remains under partial injunction and the lilac blooms each spring, whether we are ready for it or not. My sister and I have a ritual of sharing holiday meals mediated by lawyers when necessary. It is not a happy ritual, but it is honest. I continue to run the clinic. It is small but stable now. The grant money allowed me to hire a part-time coordinator, which changed everything about the hours I could cover. People come to the clinic not because it is a grand solution, but because it offers a steady hand when paperwork smells like a dead end. That steadiness is the real reward. One last quiet outcome. The governor's aide sent a letter after the legislation hearings thanking me for my testimony and saying they had used my case as a template for a statewide training module for elder law attorneys. The letter was bureaucratic, but it meant that my experience would become part of a curriculum, an administrative tool for prevention. It did not heal everything, but it shifted the power dynamic from private family decisions to a public framework that recognized harm. I do not end with vindication. The family is still imperfect. I still feel the bruises of those anniversary words, and they will not entirely fade. I do end with the awareness that evidence matters, that mistakes, small, careless mistakes, can open doors, and that public attention, when used judiciously, can force processes to correct themselves. I learned how slowly the law moves and how quickly it can be galvanized when people with influence take a look. I learned how fragile dependence can be in a house where the ledger always had the final say. If you stayed with me this long and the story landed for you in any way, please leave a like. If you want to hear more stories like this one, subscribe. And I'm curious, have you ever been surprised by a family decision that felt final and then changed by a small, unexpected piece of evidence? Tell me in the comments. Tell me in the